have the masterclass Nymphos Brow we're really excited about. So for Nymphos, proven experts with a dedication to their clients and the law, Nymphos Brow attorneys offer big firm experience with boutique personalized service. They focus on being strategic business partners to their clients. From venture capital and private equity to protecting intellectual property and mergers and acquisitions, Nymphos Brow is a different kind of law firm supporting entrepreneurs, emerging and mature companies. Today, we're pleased to have Nymphos Brow of counsel Michael Antone to present the Entrepreneur's Guide to Intellectual Property. A U.S. registered patent attorney with more than 20 years of experience, Michael Antone serves as of counsel of Nymphos Brow, where he helps clients protect their most valuable intellectual property assets. He also has experience in corporate and business law, private equity, and as a professional engineer. So Michael, with that, I will turn the time over to you for the masterclass today.
Good morning, everyone. Thank you for joining us, and thank you for that kind introduction. As the scholar said, today we're going to be talking about the entrepreneur's need for to kind of give you just a background so you can move forward and think about intellectual property with all the myriad of things that an entrepreneur must do. So, from an agenda perspective, we're going to do have several tasks. We're going to talk about what is intellectual property in general. Why do entrepreneurs need to know about intellectual property? Why is intellectual property important? What are the different types of intellectual property? How do I protect my intellectual property? That should chew up most of the 1 hour. And we'll summarize at the end. And if we've got a little bit of time left, we'll answer questions either as part of this call, part of this webinar, or we will get back to you offline. In general, the way this presentation is laid out is we're going to talk about the major areas of intellectual property. We'll walk you through things. There's a lot of material in the slides that because I think the goal is to make this somewhat of a reference for you. Just say, oh, you know what, I remember what Mike was saying about trademarks. Let me take a look and get some background there. And so we will provide the slides to all the participants after the presentation, and we'll probably augment it with any questions you might have or any additional information we can provide, so that it does give you a work where you can refer to it if you have to. But feel free to post questions in the chat, and I said we'll get to them either at the end of the presentation or afterward. So moving right along, what is intellectual property? It is a form of intangible property, obviously meaning not tangible, but not all intangible property is intellectual property. Intellectual property is property created by the mind. What do we mean by that? Just look around. Everything you see around you, with the exception of the ground, the air, basically the basic elements of the earth, is the result of intellectual property in its frozen form. Intellectual property, somebody had to invent and develop everything you're doing, from the car you're driving to the computer you're working on to the desk where you're sitting in, chair that you're sitting in. At some point in time, somebody had to develop that. That is intellectual property. It is the creative genius of the human species, and in its frozen form. With that large buildup, the answer to this question is probably fairly straightforward. Why do entrepreneurs need to know IP? Is because every business has intellectual property. We'll dive into that in a little bit more detail. And whether you know it or not, your intellectual property may be one of the most significant assets of your business. How important is intellectual property? It was sufficiently important that the founders of the United States, when they put together the Constitution, built it into the Constitution. That's for those of you who are familiar with the Constitution, it is a structure where there's not a lot of detail, provides a framework. But in two sections of the Constitution, they specifically called out that inventors and authors should have the exclusive right to their writings and discoveries. And also, we'll get to it later, is the regulate commerce. And that impacts the way the various intellectual property laws are put together. But there's a general recognition, even at the beginning, that if you want somebody to be creative, you gotta help them protect their property so it doesn't get ripped off. Simple as that. If you need to invest time and money to make something happen, then I need protection for that. And it's because it is intangible. You need additional protections. So how important is it today? Let's take Apple as an example. Apple has over 24,000 US patents. And because of Apple's largest company in the world, that's just the US patents. There's a significant chunk of patents that are in the major economies around the world, but that's just in the US. There were 1,500 US trademark registrations and applications. And you think about that, that's somewhat of an amazing number, because you think of the name Apple, you think of the apple with a bite out of it, and you think of iPhone and iPad. But how do you get to 1,500? That shows the importance of trademarks to Apple. In addition, they have over 5,000 US copyright registrations and applications. Again, you don't really think of Apple as a content creator until you start thinking about what are the types of things that can be protected by copyrights. And we'll get to that. How does all that roll up? For those of you that are financial folks, in the year 2020, Apple has over 42 billion in other non-current assets on their balance sheet. That is the place on the balance sheet that where intellectual property resides. Is it all 42 billion of that as intellectual property? No, but it represents a substantial asset of the company. And for those of you that are fans of Apple products, they don't sell anything at a discount. And that's why they can have so much value built into their balance sheet. And with that lead in, we'll talk about what are the different types of intellectual property. First one is know-how. Know-how is the most common form of intellectual property. It is basically what you do, how you do it, who are your customers, who are your suppliers. It's everything that goes into your business. Just how you do what you do, and the reason you're able to do it and actually have a business. The next form of intellectual property is branding. We just talked about Apple. Apple is probably one of the most valuable brands in the world, and so that when you see their branding, it's Apple. They don't have to put the name Apple; they put the little apple with a bite out of it, and everybody knows what it is, or just about everybody knows what it is. You've got your inventions and discoveries. This is the intellectual property developed by the development teams. Everything that goes into an iPhone, everything that goes into the iPads and all the other devices, and then everything that goes into all of these products that you see around us. The last one is your creative work. Creative works are any type of content that you develop. The internet and the growth of the internet and all the social media has created an explosion in creative works. It used to be a small area where there were publishers and there was only a few people doing it, but now the creative work, intellectual property is available to everyone, basically, at this point in time. How do you protect your intellectual property? Intellectual property rights. With know-how, you protect you protect your know-how with contracts. So the people with whom you're dealing, whether it be vendors, whether it be your customers, is the form you're going to be doing. That's the importance of making sure you have the proper agreements in place. And we're going to go through these quickly, and then we'll talk about each one of these forms of intellectual property, give a little bit more detail on the type of things you want to be thinking about as you go forward. Branding is protected with trademarks. So as we tie it back to our Apple discussion, that's why there's over 1,500 US trademark registrations and applications from Apple, is the need to protect that brand. Inventions, you're going to be protecting those. You got two options with inventions: you do patents or contracts. We'll talk a little bit more about that later, and what are the two options and how you go into different directions. Creative works, those are your expressions of your ideas. And that you protect that with copyrights and contracts. Your expressions are, there could be written, they could be visual, they could be audio, all of those types of things. Software is the expression of an idea. What are IP rights? This is an area that there's oftentimes a little bit of confusion. IP rights are the right to exclude others from using your intellectual property. So with each form of the intellectual property, with a contract, for example, with respect to know-how, I am agreeing with one party is agreeing with another party to use their intellectual property for certain purposes, and they're agreeing to not use it for other purposes. A patent is the right to exclude somebody else from using your invention, but it is a right to exclude. The right is conferred by a jurisdiction, so a governmental entity, or contract between private parties. The importance of being conferred by a jurisdiction as copyrights, trademarks, patents, they are all conferred rights by a jurisdiction. The end result of that is, for any jurisdiction where you may happen to be doing business, you need to apply to those jurisdictions to try to get the IP rights that you need to enforce in any particular country, which, as you might have guessed, can get to be quite expensive when you start to think about all the various countries in the world and places you might want to do business. Enforcement is actually by a lawsuit in the court's jurisdiction, whether somebody is in breach of a contract or whether somebody is violating your trademark, patent, or copyrights. So what we're going to do now is we're going to dive into each of the forms of IP, talk about a little bit more about each one of them, give you a little bit of background on how you get the rights, what's involved with the rights, and give you a few takeaways so that when you're out running your business and these issues come up, you say, okay, I remembered I needed to do this from our talk, or I need to ask Mike this question. But know-how, as I said, it's everything about your business. It is all the sum total of what you need and how you go about doing your business. It includes your trade secrets and other confidential information. It also includes non-confidential information, the things that your consuming public sees. So it's not necessarily even confidential, but it is the sum total of your business. But the important aspects of it are the trade secret and the confidential information, because the publicly viewing information is not protected. Now, confidential information and trade secret rights, they come into existence the moment you possess the information. So you have it. It is yours as soon as you develop it. But it must be protected. And the way you have to protect it is with contracts. And for those of you, you got your contracts with your employees. Those are the various employment contracts that you work with, whether there's non-disclosure agreements, proprietary information agreements. All these things are extremely important because you're going to be disclosing your confidential information to your employees to help you in the conducting the business. And you need their agreement to not disclose that information. The other place where you're going to do it, the other people you touch are your vendors and your customers. Non-disclosure agreements and non-disclosure clauses with other agreements. Are the typical way you're going to interact, particularly with vendors. With customers, you have a different form of agreements, but some of these agreements are going to be formed like end user license agreements. Everything you don't read when you're downloading an app and you're clicking through, those are in there. They have, in particular, restrictions on how you can use their know-how. What you're signing up there is you're agreeing to protect their information and not reuse it. How long can you protect confidential information and trade secrets? As long as you can keep it a secret. That's the importance of making sure that you get commitments from the people that you are exposing your trade secret and your confidential information. It's important to get agreements with them, but as long as you can keep it a secret, then you have protection. And so we'll talk about it a little bit later, but the most common example that comes up when we're talking about trade secrets is the Coke formula. Coke formula has been a trade secret, I think, for over 100 years now. And we'll talk about that decision to keep it as a trade secret. But it is, a lot of times we talk about trade secrets as being a special sauce, referencing to McDonald's. But how you make a French fry the way you make a French fry, and nobody else can seem to make a French fry that tastes like that French fry. How much does it cost to protect your know-how? This has just got to be part of your normal business due diligence. It's nothing out of the norm. If you're putting the correct agreements in place, fairly standard agreements with those people that are involved in your business, be it the employees, be it the customers, be it the vendors. As long as you get the proper agreements with them, you can maintain it. Obviously, things like trade secrets. We'll pause for a moment. Trade secrets are a special class of confidential information. Confidential information is anything that's not generally known to the public. A trade secret is something that's as confidential information, so it's not generally known to the public, but it also has an independent economic value by virtue of the fact that it's not known to the public. So again, to Coke, the Coke formula, right? Nothing tastes like a Coke, whether you like Coke or not. That's the general thing. And so there is an economic value associated with a trade secret that's not associated with any other confidential information. Therefore, you need to be a little bit more careful with trade secrets. And you really want to kind of keep a tight circle there. And that's why there's not very many people that know the Coke formula. Which kind of leads to a good lead into the takeaway from contracts is, beware of NDAs, if most everybody's familiar, non-disclosure agreements, whether they're in a standalone agreement or whether they're inside of another agreement. A lot of companies like to put time limits on their duty to protect confidential information, particularly big companies. They want these things that most times it's not anything nefarious. It's the fact that they have to deal with so many people that they want these agreements to sunset on their own so they don't have to continually manage these processes. The problem with NDAs that have time limits in them is that all of a sudden Your confidential information is no longer, your agreement is expired. And for confidential information, a lot of times that may be dated and not relevant. But for trade secrets, if all of a sudden you've removed the duty to protect out of a non-disclosure agreement, your trade secret, you may have lost your trade secret rights. And therefore somebody could turn around. So, Coke's not signing anything that has a time limit on the duty to protect confidential information. But as I said, that's one of the things you want to look for when you're signing agreements is if it's there, then you probably want to try to get that out of the agreement. And it could be an indication that there's other things that you need to consider in there. Moving right along, we're on to brands, and we protect brands with trademarks. Again, as I mentioned, branding is how you distinguish your goods and services from the goods and services of other people. Now, keep that in mind when you're, this is a very important point that sometimes gets lost on people is when they're selecting brands. The goal of a brand is to give a point that people can latch on to remember your goods and services relative to somebody else. Apple has nothing to do with computers. So therefore it's memorable when it comes to computers. So when you're picking names, Amazon has nothing to do with online retailing. And so when you're picking brand names, you want to pick things that are going to distinguish you. As I've said to people, if I have a barber shop on Main Street, calling myself the Main Street Barber, it's not really a good name because anybody else that's a barber on Main Street is also the Main Street Barber. So when you're thinking about branding, you want to think about, okay, let's pick names and graphics that are going to distinguish my goods and services. And then once you just decide on your branding, the trademarks are how you protect your brand. And the brands deal with names, with graphics, with the logos and how you combine the various graphics. It has to do with the look and feel of your business. For example, if I told you there's a restaurant out there with alternating red and white stripes on awnings and a bunch of junk on the wall, you probably know what the restaurant is. That is also part of the branding. All right, so that we can't go off tomorrow and start a restaurant that has similar features. Although there are people that have tried with green and white stripes. Common law trademark rights come into existence the moment you use a brand to label goods and services sold in commerce. So the common law is a right that is created and recognize that once you do something, you have certain rights that accrue to you. So everybody starts getting rights in a trademark the moment you start using it to identify it. So if we decide we're going to stamp a big X on a product and start sending it out, whether or not we can protect it, but is a different question. But the initial question is that big X is now my trademark. That's how I'm identifying the product that I'm sending out or a service I'm doing.
You muted yourself, Michael.
I think I did mute myself. I didn't want anybody to hear the next part or to create anticipation, I guess. U.S. and state and jurisdictional registrations will give you additional trademark rights. In the common law, your trademarks, your rights are tied to where you're actually doing business. When you go at the jurisdictional level, like the U.S. trademark will give you registration that provides protection across the entire country. A state registration will provide you additional protections across the state. When we were the dichotomy between the US and state registrations are there for a particular reason. When we were talking about the US government, the founding and the rights, the IP rights that were identified in the Constitution, there were two different things. And one of them, trademark registration rights, come from the Congress's ability to regulate interstate commerce. So what that means is if you're only doing business in one state, you're not participating in interstate commerce, you're participating in interstate commerce. And if you're only doing business in one state, then you want to get a state trademark. If you're doing business in multiple states or across country lines, then you have you can get the protection of a U.S. trademark, which is different than patents and copyrights, which were in a different clause of the Constitution, where there is no state copyright and state patents. So just a little aside there, but for a U.S. patent, you got to use the brand to identify yourself as the source of the goods, and you've got to transact. You got to engage in interstate commerce. So you got to be doing, I think, between states. In small states like Maryland, and in the modern internet era, it's really not hard to engage in interstate commerce. 100 years ago, most commerce was not interstate commerce. So following along the lines we did with respect to know-how, how long can you protect your brand? Indefinitely. As long as you continue to use your trademark to identify you as the source of the goods and services. So there are trademarks that have been around literally for hundreds of years. I think in England, Bass Ale is trademark number 1. But as long as you're using the mark, then you have the right to continue to use the mark. How much does it cost to obtain a trademark registration? Usually for basic trademarks, you're looking at, it's fairly cost effective. You're looking at maybe $1,000 or $2,000 to register, to go all the way from filing through registration, depending upon what you're trying to do and then the amount of goods and services you're trying to put, that number can go up or down. But just from, I'd like to give people when they're doing business planning, ballpark type numbers. Of that type of number, half of that number is usually spent up front. The other half is usually spent through the process. Unfortunately, we lost one, but I'll talk about some more if we can back up. I don't know if we can back up on this. So I apologize for that. But where I was going was the time involved to get a trademark registration, it used to, there you go. It used to be fairly quick. In the last year or so, the timeline has stretched out. So it used to be, you would start getting the examination of a trademark application would begin in like 3 months. Now it's close to 9. But nonetheless, the key thing with filing trademarks is to get in line, because there's 2 important dates when you're involved with trademarks. First important date is the date you start to use the mark to identify yourself as the source of goods and services in commerce. The second important date is the date you file your trademark application. If you get in a conflict with another party about who has trademark rights, and if you have 2 people with confusingly similar trademarks, those dates will generally determine who is entitled to use the mark. If you have both of those dates on your side, you're probably a winner. If you have both of those, if the other side has both of those dates, you're probably a loser. So, very important. The takeaway from the trademarks is, for those of you who have had to write checks to marketing firms and deal with all types of branding and website development, the cost of rebranding will dwarf the cost of trademark registration. So register your trademarks. It's generally a no-brainer. When you look at it, the periodic maintenance fees, what happens when you do get a registration, you have to periodically file forms and make declarations that you're still using a trademark and you pay a maintenance fee, but it's minimal in terms of cost. You're looking at 100 on average, $100 a year to maintain a mark in one class. So just build it into your budget, get it done. You don't have to you don't have to register every trademark, but make sure you're getting the big ones in your business. Moving on. So inventions and discoveries, your inventions, discoveries, other developments, that may be what's driving your business. You may have come up with a better way to install an HVAC system. You may have come up with a better software, better electronics, everything that may be what is the key know-how of your business is possibly tied up with it's your inventions and discoveries. So he said patents or trade secret rights are how you protect your inventions. So the key thing with there is you've got to decide, do I want to protect something with a patent or do I want to protect something as a trade secret? As we mentioned earlier, common law trade secret rights, they come to existence the moment you create the invention, right? As long as you're keeping it secret. Your patent rights do not. And we'll get into this a little bit more, that patents are very different than other patent rights, than other intellectual property rights, particularly copyrights and trademarks. Patent rights do not come into existence upon the creation of the invention. Whereas, as we've already said, trademarks do, trade secret rights do, and we'll get to copyrights, they also do. Patents do not. Also, patent rights are lost. Not only do they not come into existence, but they're lost if you don't disclose your invention to the public before the filing. If you do disclose your invention to the public before filing a patent application. This comes back to haunt people if you don't know this ahead of time. By the time you've decided that you have something that you think you need to protect, you've already been out there and put it out on your website, and then your rights they may be lost. Some countries have absolute novelty requirements, which means once you disclose something to the public, all your rights are gone. The United States is probably the most generous, and the United States, because they recognize the cost of intellectual property rights, the fact that the timing you need to protect your patents, protect your inventions, is probably the time when you don't have the money to do it. Depending upon the circumstances, you can get up to 1 year from your first public disclosure to file a patent application in the United States, which is nice if you have to, but you don't really want to have to rely on that, because I said the moment you disclose something to the public, you're starting to lose your rights around the world, and they're just continuing to peel off, with the United States being the last one. I believe, to peel off, and for probably this audience, the most important one. But you don't really, as I said, you don't want to rely on that. So make those decisions early. Patents are for a very limited term, and they are expensive to acquire and to maintain. Now, I'm a patent attorney. It's my job. That's not a very good selling point right there. But relative to the other forms of intellectual property, they are substantially more expensive. Then when it comes to patents, as I mentioned, it's a short time period. There's when you file a patent application, your invention is the term of the patent runs for 20 years from the filing date of a utility patent application. 15 years from the issue date of a design patent application. So we'll pause for a second there. There are actually 3 types of patents that you can get. One of them is a utility patent. One of them is a design patent, and the other one is a plant patent. We're not going to spend much time on plant patents. I didn't even put it in the presentation, but if you're somebody that's doing new species of plants and you would like to discuss it further, just let me know. But plant patents, as they would sound, they're limited to plants. Utility patents and design patents. When people talk about patents, they're usually talking about utility patents. Utility patents are there to protect the utility of an invention, the functionality that's involved in the invention. As contrast to design patents, which are design patents are there to protect the ornamentality of a design. So utility is for function, design is for ornamentation. One of the rejections you get in a design patent is that you're trying to claim functional features as a design feature, that's one of the limitations. So, but when most people talk about patents, they're typically talking about utility patents. But those of you who are out there doing design work, design patents are one of the tools in your toolbox. Another one of them being copyrights, and the third one being trademarks, depending upon where the designs fall. How much does it cost to obtain and maintain a patent? It varies significantly, as you might expect, but it's typically going to be in the thousands of dollars. As you might expect, if your invention has to do with a new handle on a screwdriver, that's probably going to cost less than if you've re-architected the internet. So it's kind of obvious there, but you will expect by the time you start, even with the governmental fees, the costs do stack up. In the United States, you do have to maintain a patent, but fortunately, the fees in the United States are much more manageable than in other countries. But you do have to maintain a patent over the life of a patent. It will cost you several $1,000s to maintain a patent if you're getting granted over the life of the patent. Why do patents cost so much? This is a question I have to answer all the time. And it's the disclosure requirements. So a patent, the quid pro quo, as they say, of a patent is that in order to get this right to exclude people for 20 years or 15 years, depending on, you have to make a disclosure to the public of your invention in sufficient detail to enable one of ordinary skill in the art to practice your invention upon reading your application. So if you're re-architecting the internet, you're going to probably have to spend a lot of time describing how you're re-architecting the internet. And it just takes time to do that. So that's why putting together a document that meets the written description requirement is a significant undertaking. Even on the design side, if you've got intricate designs, you have to, oftentimes you'll have to employ specialist draftspeople that are drafting the drawings such that they can represent your design in sufficient detail so that you're able to protect it. And there's a lot of nuances in how you prepare a design application. And a lot of those costs don't actually often go to the patent attorney. They actually go to the draftspeople that have to put together. Some industries and some people in the modern era, they have drafting, many more drafting tools available to them, but it can get expensive. But if you have those capabilities, design patents are often much less expensive than the utility patents. So the big takeaway with respect to patents and inventions and discoveries is, you want to assess, the importance of your inventions and discoveries before you disclose them to anyone. Now, before we were talking about, you can protect your inventions and discoveries using patents or trade secrets. So the question that comes up all the time is, How do I decide whether I should protect it, the invention with a patent, or I should protect it as a trade secret? And there's a couple different things to consider. One is, will your invention be either explicitly or implicitly disclosed to your competitors when you put it out on the market? If everybody is going to be able to look at what your product or your service is and see what your invention is because it's embodied in the product and service, then you're not going to have any trade secret rights because it's going to be known to the public. And if that's the case, then the only protection that you're going to have on something that becomes obvious to the public is a patent. And then when you're thinking about, patenting, you say, does the value of the invention exceed the cost of getting a patent? So if we say, okay, it's several $1,000s, maybe it's between $10,000 and $20,000 given your patent. Am I deriving value from getting a patent, or is it something where it's patentable, it's neat to have, but I'm not going to make that money back by getting this right to exclude for 20 years? At the end of the day, it's ultimately a business decision on where you want to invest your capital. Is this something where it's worth, if I'm spending $10 million developing a product, is it worth $20,000, $100,000 to protect that investment? In those cases, yes. When you dial back the numbers, it gets much more of a yes or no. The other thing you want to think about when you're saying, unfortunately, with respect, you got to invest this money up front in the process, is a lot of entrepreneurs, business owners have said, Mike, why do I want to spend this money on getting a patent when I don't have the money to enforce it? So if a big company just decides they want to violate my patent rights, I don't have the resources to enforce my patent because they have much deeper pockets than I do. And if we get into a fight, it can cost millions. And that's a very good question. It's something that feeds into the business decision. Oftentimes when I'm talking about, in particular with startup companies, small businesses that are looking to grow and medium-sized businesses, is unfortunately, because you have to think about these things early, a big consideration is, okay, where do you want to be as a company, right? You may not be able to enforce a patent, but if you're looking to exit in the next 5 years, 10 years, the company that buys you is probably going to be interested in, and probably it may have the wherewithal to protect the intellectual property. So when you're making this decision, you want to think about, in my business plan, it is, while I may not be able to do this now, is if my business plan involves potentially being acquired, then the people that you need to think about now are, is this how valuable is this patent to the potential acquirers, and how much will acquirers value this? For those of you that are dealing right now and looking for investors, and if you're with CONNECTpreneur, you're definitely interested in investors. For those of you that have already engaged with investors, this is one of the things they talk about. They want to know, okay, you've got a great idea. How long can you protect it? The horde is at the gate, and have you done everything you need to do to protect your position in the market that you're developing? So all those things kind of feed into it. So while there's a couple questions to think about there, the business decision is much broader than that, and it looks at the audience of investors and acquirers are two of the key players that you want to think about when you're doing this particular analysis. Move on to copyrights, creative works. They're the expressions of our ideas. Basically, as I said, the content you're developing for your website. It's the marketing content. It's software that's being written. It's engineering designs that are done. It's the layout. One of the things, Apple is big on just the layout of their stores. They've copyrighted, a lot of the copyrights have to do with their GUIs, graphical user interfaces. And for those who's not up on GUIs, but any type of the expression of ideas is things that are copyrightable. Now, notice I say the expression of the idea. It's not the idea itself. In fact, you may have noticed that there's no protection for just an idea. An invention is an idea that's been reduced to practice. A creative work is an idea that's been expressed. It has to be expressed into a tangible form. As I mentioned earlier, copyrights, they come into existence the moment you create the work. So you are the owner, the creator is the owner, with the exception of when you're working for an employer. That's maybe a little deep, but those are work for hire. So the person you work for may in fact own your copyright, but they come into existence the moment you create the work. But, and there's a big but, in the United States, you need a copyright registration to enforce your copyright. So that's a big deal because there's no sense having copyrights if you can't enforce them necessarily. So let's talk about that. How long can you protect content? The current copyright laws are a long time. 70 years after the death of the inventor, 120 years after creation, or 95 years after publication, whichever is shorter. For works for hire, works for hire is if your job with your employer is to generate content, the employer owns that content and is considered the author of the content. Whereas if you do it on your own, then you are considered the author. One noticeable thing here is the copyright terms are extremely long when you consider them relative to patents. And that's because content has to do with the expression of an idea, and whereas patents have to do with functionality, with bringing technology, with bringing inventions to the marketplace. So the marketplace opens up your technology with your patented, your inventions and discoveries are made available. The decision is to make them available sooner to the general public, where making available, Fantasia in 20 years doesn't necessarily, it is a right. It's not limiting people from generating new content, whereas a utility patent, gives you the right to exclude for a period of time. Copyright laws vary all over the world. They're in a state of flux. There's large entities out there that have a vested interest in maintaining the copyright. If you're somebody like Disney, where Mickey Mouse and a lot of the iconic characters are now extremely old, you see why they keep pushing out how long you can get copyright protection. How much does it cost to obtain a copyright registration? Not much, typically a few $100s. And so if you don't generate large amounts of content, it's worthwhile to copyright your content. It's a small investment, and it keeps it gives you the right to enforce your copyright. So it's definitely worth it. If you're in an industry where you're a photographer or you're generating a lot of content, first thing I always recommend, if you're generating a lot of content, you may want to learn how to file a copyright application yourself. While that takes money out of my pocket, I'm trying to make sure that we're delivering value to our clients, and say, if you're generating that much content, you want to learn how to do it yourself so you can do it. And then you do have to make some decisions on, I'm generating, I'm generating 1,000 pictures a day. I can't protect everything because how fast I can generate content. And then you got to make some decisions there. But for most content generators, you want to identify your important content and you want to protect it because it's just a very small investment. The takeaway from this again is you want to copyright any creative work. You would want to do it before or near publication so you can maximize the recovery for any infringement. Your copyright is infringed if somebody actually copies your work. If two people go off and with an idea of writing a story about a war in an ancient land and they end up with something that's very similar, if they didn't copy it from one another, the mere fact that they both had an idea to write something that Marvel will pick up as the 100th movie in the series, the fact that two people ended up with a similar work product does not matter with copyright is copying. But there's a key aspect. If you register your copyright before it is published or within a few months of publication, you can get what's known as statutory damages. And statutory damages are you don't have to go through the time and expense of proving what your actual damages were by somebody copying your work. You can look to the statute and say, I'm entitled to this much because my registered copyright was infringed. So very important to, if you've generated and invested an amount in creative works, to get that content protected because it'll make your life much easier if there's ever a problem with infringement. And now we've kind of tore through most everything. I don't even know how we're doing time-wise. So we're right there.
We've got some questions that we can address.
Okay. We'll give a quick summary. The main thing I want you to think about is the time to think about IP is before you go to market. As I said, you don't want to start investing time and money into intellectual property and not protect it. The different types of intellectual property and how you protect them, quickly running through them, know how you do with contracts, branding, you do with trademarks, inventions, you do with patents or contracts, creative works, or copyrights or contracts. Remember, kind of the end result is that if you protect your intellectual property up front, it'll pay dividends and it'll prevent difficulties in the future. The time to think about it is early, and there's so many things going on with entrepreneurs, with starting businesses, that this is one of the things that often slides, and you don't want it to slide. I registered a trademark for a company. His date of first use was, I think, 41 years earlier, and then he had a trademark problem, and we had to go register the trademark. And you don't want to have to go back and have the ship sail on you in this, because if you lose your trademark rights, oftentimes there's no real good way to recover. And that's all I have.
I'm going to throw some questions to you from the chat.
Okay.
And we'll start off with trade secrets. And what's the statute of limitation on trade secrets?
Well, a trade secret, there's a trade secret, as I said, can be protected as long as you can keep it a trade secret. In terms of where a statute of limitation would come in is there's various trade secret laws in the states and at the federal level. So bringing an action to enforce somebody's theft of a trade secret will depend upon what's stolen, where is it stolen. They're working. I said the Federal Trade Secret Act. I'd have to follow up with a specific date on that, but in terms of the statute, there's no limit to how long you can protect it. There is a limit to once you know your IP's been stolen, how long you have to try to enforce your rights. And that's true with all the intellectual property. Over a period of time, if you know that somebody is infringing your rights, if you let it go long enough, the courts will say, you know, you let this person operate for years. You know, the ship has sailed for you on getting your on maintaining your intellectual property. And it's just because it's just fundamental fairness. You can't let somebody go off and invest all their time and money and say, oh, no, it's fine, it's fine, it's fine. And then no.
On patents, how do you assess whether or not something is patentable? How do you value that patent? And how do you check for conflicts?
Yes, so one of the things you do with respect to trademarks and patents in particular is you'll do searches. And as you might expect, trademarks are a lot easier to do searches on. Patents, you do patent searches, but there's for anybody that's interested in patents and trademarks in particular, if you go to the U.S. Patent Office website, which is www.uspto.gov, there's a lot of information on patents and trademarks. In the United States, patent and trademarks are separate from the Copyright Office, which is under the Library of Congress. But the U.S. Patent and Trademark Office site has a lot of information. Trademarks are easy. I usually almost always will say when somebody's asking me about getting a trademark, I say, have you done a web search yet? I mean, if you just go onto an internet search, and sometimes maybe you use different search engines, but do an internet search and see if anybody has, you know, just pick the name Apple to sell mobile phones. And really you want to do that. I'd hate to have people come to me and want to start spending money and say, do this fundamental research. You don't need a trademark attorney. You don't need an attorney. Just in a modern era, just about everybody's good at doing browser searches. Patent searches, you can do patent searches on the Patent Office website. I would not go to private sites like Google Patents. I would tend to avoid private company sites with Google. Google in particular, because Google tells you they track everything you do. So you probably don't want to go into Google and type your great new invention into a browser that they've told you that they're monitoring. So you want to, but you can do all that at the U.S. Patent Office.
And how do you value in terms of how do you determine the value?
You know, the value of a patent is really comes down to, you know, it's got to be assessed by the business owner. Is my invention, does it give me an economic advantage in the marketplace? Does it give me a way around somebody else's patent? So it really kind of comes down to what value is it bringing to my business? And, you know, how can I protect that value? Again, when you're looking down the field from investors and an acquirer standpoint, is how much value do you think that will bring to the larger company that buys me when I'm doing the exit?
We've had and Skylar, I know we're at the end of time. I know there were several questions about NDAs, and these are things that we're happy to answer offline as well. So kind of in our follow-up to everyone that has joined.
And just a quick note on NDAs. NDAs, you know, people take a very casual attitude to NDAs, and it's probably due to the fact that, you know, NDAs are everywhere. But and so people don't think like, oh, the NDA is an important agreement. It's like, well, gee, I do this with everybody, so it's just kind of the standard process. But an NDA is the only way you protect confidential information, trade secrets, your discoveries and inventions that you decided not to patent. So they're very important documents, and it's just important to get those set up with everybody. But don't discount the value of an NDA, because it could be the only thing that's protecting your intellectual property.
Over to you, Skylar.
Okay, great. So I know we didn't get to all the questions as Joe was saying. But if you would like to have a follow-up with them or get into your questions more, feel free to leave your email in the chat and Jill can take that down, or Jill can put her email in the chat and you can email her. We really appreciate everyone being here today, and Mike for the awesome presentation. This recording will be posted on our YouTube channel, and it will also be emailed to you. So if you missed the first half or the last half or any parts in between, you'll be able to rewatch it. And we are looking forward to seeing you all soon. So thank you so much for being here.
Thank you.